Hello, and welcome to this episode of CDR in 10 on data breaches. I'm Tori Mills, an associate in the commercial disputes team here at TLT.
And I'm Kate Ward, a senior associate in the same team.
So Kate, I think it's fair to say the nature of these disputes has been changing over the last little while. Are you able to give us a bit of an explanation about what's been going on?
Yeah, absolutely. I mean, we've seen a sizable impact in data protection claims over the last few years. And I think that's just as people naturally become more alive to the uses of their data and the collection and collation of it. So yes, I mean, we're seeing this pendulum swing as well between a more generous approach to claimants and perhaps a retrenchment from that. And in a sense, it kind of feels a bit like the Wild West, with sort of principles being developed by the courts and by government, claims being staked. It's quite an exciting time to be a practitioner in this space, and probably quite interesting for our clients as well. And obviously, as you'll be aware, the ICO can't award payments to individuals who've suffered losses as a result of data breaches. And that means that parties are tending to go to specialist outfits or claims management companies who advertise on Google or social media. And that in itself is obviously fueling this rise in data protection claims that we see now.
I heard you describe the courts as the Wild West there, which is a description I quite like.
Yes, I mean, it kind of is like that. It's just a time of uncertainty and this feeling of like expanding and contracting in the case law that you tend to see when there's any new sort of development. Like, for example, we saw that in Lloyd and Google. Before that, we thought that these things could be brought as a representative action. In Lloyd and Google, it was held that actually, because of the individual nature of these claims for distress, it wasn't appropriate. So we sort of moved away from that again. But now we're looking at new case law and there's new statute coming through. So again, it's changing all the time. And it also, of course, businesses are the focus of the government, and the government also wants to help individuals. And there's the background of Brexit, because we had a lot of our legislation from EU law. So yeah, it's really exciting times.
And these disputes, they can arise for all sorts of reasons, whether that's cyber attack or through human error, people sending information to the wrong people or granting unauthorized access. I wonder if we could just focus on some of the pivotal questions that organizations will have to deal with when handling a claim.
Yeah, I mean, absolutely. One of the most obvious, which often gets missed just because it is so simple, is whether there actually has been a breach. So a lot of the time, clients will come to us and they'll say that they think there's been a breach and how do they deal with it? And that's because a customer representative has received a complaint from a customer. They've sort of said, I'm sorry, they've given them a goodwill payment, which is fairly standard in these companies. And then actually, when you drill down into it, you realize there hasn't been a breach at all when you look at the facts. There's some other reason that this individual's managed to get customer information. So it's important to interrogate that at an early stage and not just accept, the initial conclusions. Think about the heads of loss. So we know now that claims for misuse of private information and breach of confidentiality, they need a positive act on the part of our clients. So our clients need to have done something. It's not really appropriate for cyber attack claims. But a lot of parties who sort of bring these matters through these specialist firms, they use template letters. So they're really throwing the kitchen sink at it in terms of all these causes of action. And that's used to increase the pressure on clients, but you really have to understand that some of these just aren't appropriate and they can just be ignored. Think seriously about the distress that's being claimed. So again, before Lloyd and Google, we had this concept of loss of control. So you could get some kind of a financial compensation, even if you weren't upset by the loss of your data, just by the fact it had been used without your consent. We've moved away from that now. There does have to be some kind of distress or loss suffered. But again, the courts are using this case law to develop a more restrictive approach to that again. So they're saying, actually, we all live in the 21st century and you have to have a sort of minimal level of fortitude. Things do happen, emails do go to the wrong people sometimes, but we all understand that where that data is not sensitive and it can be deleted, that actual damage is going to be minimal. Think about DSARs. So we often see bulk DSARs as a prelude to group action or representative action. But think seriously, do the people making that request for a DSAR have authority to make it? Can we identify the parties who are requesting their data? And is the request the appropriate subject of a DSAR, or is it more, a pre-action request for disclosure? And lastly, just briefly, vicarious liability can sometimes be important where customer services representatives have used data inappropriately. Were they doing that in the course of the business to which they've been employed, or were they doing that for their own purposes? So that's just a few initial thoughts, obviously.
And Kate, we know it can be difficult to avoid group action, but what about individual claims? What sort of things should organisations be thinking about when those come across, when they come across those?
Yeah, so have a think about approaching them head on. So think seriously about what's happened, have a look at the processes, who's received the data, and make sure you take appropriate steps to ensure that third party deletes the data if they need to. That sounds like a sort of minor step, but actually courts have shown that they're prepared to be much more lenient to parties who have taken those steps as a matter of urgency. So they've acted to try and mitigate the losses and protect the person who's lost their data as far as possible. Consistency is important. So in these types of businesses, obviously a lot of people can get involved in these types of data protection complaints, from customer services representatives and members of the business to business leaders who can sometimes receive complaints directly and in-house. So ensure that everyone's sort of singing from the same hymn sheet when it comes to that. And lastly, in the matter of costs, when these sort of case management companies or specialist firms bring these claims, obviously they're very interested in recovering their own costs as well as the damages of the claimant in question. And that has two implications. Firstly, they'll tend to issue the claim in the High Court on the multi-track in order to ensure cost recovery. And secondly, they'll make Part 36 offers and generally refuse to do cost inclusive discussions or even tell you what their costs are. So it can feel a bit like you're negotiating blind. And in that situation, it's important to try and apply to transfer the case onto the small claims track as soon as possible. And we've seen that courts are getting more and more receptive to that, especially as more cases are coming through the High Court.
Those are some really helpful practical tips. Is there anything else that firms should be considering?
Yeah, I mean, document retention is always an important one. So for data protection claims, you have 6 years to bring them. So clients are properly deleting documents which they don't need to retain. But equally, when a claim is intimated, you need to think seriously about what documents you might need to get hold of. So emails or statements from people who are involved. Think about early applications for summary judgment or strikeout if there's heads of loss which are inappropriate or heads of claim which the facts simply don't bear out. And obviously take specialist legal advice, I would say that, but sometimes very early on, the costs of these matters can outweigh the sums in dispute very early on. So it can be appropriate where there's not a point of principle involved to try and negotiate them to get a good settlement as possible.
And looking to the future then, how do you see claims for data breaches evolving?
Yeah, so there's this possible impact of the data protection bill, the data reform bill, which is coming down the track, and that will mitigate burdens on businesses. And it will change the threshold for refusing a DSAR from manifestly unfounded or excessive to vexatious or excessive. So that should hopefully reduce the burdens on business. And there's also going to be more of a focus on having an internal process for addressing complaints before they're reported upwards. So again, that's sort of the government trying to help business in this new data-driven world. But I think generally, just as cases continue to increase and the courts have a look at them and the government continues to legislate, there's going to be more and more case law and important changes in the law to keep abreast of. And there's going to be more clarity on some of the principles I've discussed.
Great. Thanks so much, Kate.